arrested, mandatory detention, release, and bond. Welcome to Immigration Television, your guide to the ever-changing laws and regulations of U.S. immigration. My name is Tarek Hashmi. I'm an immigration attorney in Miami, Florida, and I'll be explaining to you mandatory detention, release, and bond. This video describes what happens when a foreign person, also called an alien in the law, is arrested and detained, and how he or she can be released. This video will assist immigration attorneys seeking clarification on the law and some of its technical provisions, as well as affected persons seeking a basic understanding of this complex area of law. Please note this is a very complicated area of immigration law. There are three distinct statutory provisions that authorize immigration-related detention. INA Section 235B2A. This section authorizes detention of arriving aliens. Number 2. INA Section 236. This authorizes detention while removal proceedings are pending. INA Section 241A5. This authorizes detention after a final administrative order of removal. Whether a person can be released and under what conditions depends upon which statutory provision applies. Let us first begin by reviewing the first one. This is the detention of an arriving alien. The statute provides that individuals who are seeking admission into the United States shall be detained if they are not clearly and beyond doubt entitled to be admitted. Section 235B2. This applies to 1. Individuals arriving at the border seeking entry into the United States. Number 2. Individuals who have entered the United States without inspection by an immigration officer and who are not admitted when they cross the border. Let us apply the first one to arriving aliens. Once again, arriving aliens can be taken into custody if not clearly and beyond a doubt entitled to be admitted. Traditionally, such individuals can be released pursuant to the parole provision, although in most cases one will unfortunately find that DHS, which is the U.S. Department of Homeland Security, they will refuse to grant such a parole. INA Section 212D5 permits the release under certain conditions for urgent humanitarian reasons or significant public benefit. A person can be released on bond pursuant to this provision. The critical point here is that the decision is made by DHS officers. In this circumstance, the IJ, the immigration judge, he has no jurisdiction to review the release decision made by the DHS. For those cases in which the immigration judge has no jurisdiction, if one encounters the situation where DHS refuses to release an arriving alien from detention, then the only recourse is to file a habeas petition seeking judicial review in the applicable federal district court. Now, individuals who have entered without inspection. Individuals who have entered without inspection and are apprehended while inside the United States are regarded as seeking admission. Such individuals are eligible for release under bond pursuant to INA Section 236, and if one is not satisfied with the DHS's bond decision, such an individual has a legal right to have a bond hearing specifically conducted before the immigration judge. Release of arriving aliens under INA Section 236. All right, this is a very common question, but there exists no case law on this issue. Therefore, when confronted with this specific case scenario, as no case law exists as guidance, an attorney can argue that arriving aliens subject to mandatory detention under Section 236C are eligible for bond under INA Section 236A. If removal proceedings are brought against an arriving alien, he or she shall be held in DHS detention pending a decision on whether he or she is to be removed. Another extremely important class of individuals commonly being subjected to these detention provisions are lawful permanent residents. Certain legal permanent residents who travel outside the United States may be treated as arriving aliens upon their return. According to DHS, a permanent resident who has a prior criminal conviction and is inadmissible under Section 212A2 may be treated as an arriving alien after any departure from the U.S., no matter how brief and innocent. And herein lies the irony in these provisions. Lawful permanent residents cannot be deported as long as they stay in the United States. But if they travel outside the USA, they can be barred from re-entering the country under the grounds of inadmissibility. They can be held in detention without bond for years while the government attempts to exclude them. So, for example, lawful permanent residents who were convicted years, even decades ago on minor criminal offenses covered by INA Section 212A2, they may be barred from re-entry and held in mandatory detention if they travel outside the U.S. and return. These are issues that one must be prepared to litigate, and one's client must be advised of the risks, continuing detention while removal defense is conducted. Next, detention during removal proceedings. INA Section 236A states, on a warrant issued by the Attorney General, an alien may be arrested and detained pending a decision on whether the alien is to be removed from the United States. Under this provision, an alien should not be detained or required to post bond except on a finding that he is a threat to national security or that he is a poor bail risk. Thus, if a person establishes that he or she is not a danger to the community, then the individual should be released on a bond. Flowing from this discussion is the provision set forth under Section 236C. This is mandatory detention. Section 236 also provides for mandatory detention, in other words, detention without the possibility of release on bond for certain categories of individuals. INA Section 236C provides for the detention of any alien who A. has committed a criminal offense covered in Section 212A2, or B. specified offenses under Section 237 for which the alien has been sentenced to a term of imprisonment of at least 1 year, or C. is inadmissible under Section 212 or deportable under Section 237 when the alien is released, without regard to whether the alien is released on parole, supervised release, or probation, and without regard to whether the alien may be arrested or imprisoned again for the same offense. These are very dangerous provisions indeed. Now, let us turn to the flip side of the detention concept. In other words, we are now referring to release. This decision falls upon the office of the Attorney General in the United States. Specifically, the statute proclaims that the Attorney General may release an alien described above only if the Attorney General decides that the release of the alien from custody is necessary for certain witness protection matters, and that the alien satisfies the Attorney General that they will not pose a danger to the safety of other persons or of property, and that the alien is likely to appear for any scheduled proceeding. A decision relating to such release shall take place in accordance with a procedure that considers the severity of the offense committed by the alien. Another subject worth bearing mention is that involving the issue of lengthy detention. Now, historically, the Supreme Court has held that in civil proceedings, which includes deportation cases, that detention is justified only in certain special and narrow circumstances, where a special justification, such as harm-threatening mental illness, outweighs the individual's constitutionally protected interest in avoiding physical restraint. In the immigration context, there are two such special justifications for detention. First, in preventing danger to the community, which is limited to especially dangerous individuals and subject to strong procedural protections. And second, ensuring the appearance of the non-citizen at future immigration proceedings. As a constitutional matter, if an individual does not present a danger to the community, bond should be set at a sum designed to ensure his appearance, and no more. Another important aspect in comprehending the essence of the mandatory detention provisions boils down to what is referred to in the field as the when released issue. In September of 1996, Congress amended the mandatory detention provisions, making almost all non-citizens convicted of crimes, including permanent residents, subject to mandatory detention upon release from federal or state authorities. The language in Section 236C, this requires the Attorney General to take non-citizens into custody when the alien is released, and not release such individuals. And here is one of the most important components for both the practitioner and the student to understand. Although Section 236C was enacted as part of IRERA, the Illegal Immigrant Reform and Immigrant Responsibility Act, in September 1996, the mandatory detention provisions did not come into effect until October 9, 1998. Therefore, the DHS has adopted the position that any person released from incarceration prior to October 9, 1998 is not subject to mandatory detention. Further, the when released language does not apply to a person who is released from physical custody of state authorities prior to October 9, 1998, and who is not physically confined or restrained as a result of the conviction. On the other hand, any person who has been convicted of a qualifying criminal offense and has been physically released from state custody after October 9, 1998 is, according to DHS, subject to mandatory detention. And this is regardless of when after October 9, 1998 he or she was released. Now, regrettably, the BIA, the Board of Immigration Appeals, has upheld this position. But keep in mind that there exist numerous cases which have held that mandatory detention does not apply to individuals who are released after completion of their prison sentences. Thus, one must be ever ready to raise these specific cases in deportation or while the litigation defense of the detained is being conducted. Last, bond requests. Bond requests made to DHS. Initially, DHS has authority to release an individual from custody either pursuant to its parole authority for arriving aliens or pursuant to 236, other cases. If a person is an arriving alien, the immigration judge has no authority to review the DHS custody decision unless the person is an asylum seeker. A bond hearing before the immigration judge. If an immigration judge has jurisdiction to review the DHS custody decision, the IJ can hold a bond hearing as soon as the person is in DHS custody. Now, the mistake that many people make within this context is that it is not necessary to wait until the NTA, the notice to appear, is filed with the court. Bond hearings have been held to be separate and apart from the removal hearing to determine removability. Therefore, once again, do not delay in filing one's motions for bond, etc., as this imparts a lengthy and unnecessary strain upon the detained client. Bond appeal to the BIA. The BIA has jurisdiction on appeal to review the immigration judge's bond decision. The notice of appeal must be filed within 30 days of the immigration judge's decision. It is also important for practitioners to note and to recognize that if the DHS initially sets a bond in the amount of $10,000 or more, DHS can obtain an automatic stay of the immigration judge's bond decision by filing their own EOIR 43. However, this must be filed within 1 business day of the issuance of the order, and also by filing an appeal to the BIA within 10 days of the immigration judge's decision. Should these above avenues prove unsuccessful, an individual still has one more option for relief: federal court review. A person obtains judicial review of the bond decision by filing a petition for habeas corpus in the appropriate district court. It is also worthwhile to note that there is no statutory requirement that administrative remedies be exhausted, although a court may require exhaustion of administrative remedies as a matter of prudence. Nonetheless, most courts have held that exhaustion is not necessary when a person is challenging the agency's decision to hold him or her in custody for purposes of removal. Although we trust that the above describes the major issues prevailing in this field, this presentation should not be construed as providing legal advice and does not substitute for an individual's specific case evaluation by a competent deportation defense attorney. Once again, thank you for joining us on Immigration Television.